under the influence causing serious injury. At sentencing, Judge Hamlin voiced concern that Trooper Sears-Patowski had abused his position and lied during the trial, declaring from the bench that Trooper Sears-Patowski had given perjured testimony.
Told the deputy that the defendant had been drinking prior to driving. He said, "I didn't say that. It's not on the body camera footage." So he had watched all of that body camera footage before coming into my office and coming up with this story. This is a situation where a state trooper was willing to get up on that stand and commit perjury for his wife, wearing a state police pin, mind you, I assume in an effort to lend more credibility to what he was saying.
And just so there is no doubt, the court absolutely believes that that's perjured testimony, just so everybody is clear on that.
On April 30th, 2025, Abigail Sears-Patowski was sentenced to serve a minimum of 18 months and a maximum of 5 years in prison. Trooper Sears-Patowski was arraigned in the 86th District Court in Grand Traverse County on December 15th, 2025, on 2 counts of perjury and 1 count of obstruction of justice, and he pleaded not guilty. The case was bound over to the 13th Circuit Court and assigned to Judge Kevin Elsenheimer. 2 motions came before Judge Elsenheimer on March 20th, 2026. The prosecution's motion to remand the case back to the District Court to allow for a preliminary examination on a proposed additional obstruction of justice count, and the defense's motion to disqualify Judge Elsenheimer on the grounds that his colleague, Judge Hamlin, was expected to be called as a material witness at trial.
It's when we believe that this is not exactly connected to the same transaction. Or that the count that people would like to add relates to statements made to an officer. So far, the defendant has been charged with 2 counts of perjury for statements that were made during testimony at his wife's trial, on obstruction of justice charge for statements he made to prosecutor Kyle Atwood in February of 2024. And now I believe intent is to add an additional count for statement made by the defendant to an officer. We believe that this addition of an obstruction count is just retaliatory because the defendant has chosen to exercise his right to proceed to trial and not to take the plea offer. Yet that hasn't been charged initially. The people have initially charged the defendant with a count of perjury and a count of obstruction. Then when he refused to waive his preliminary examination without having a full copy of the transcript, they added another count, amended the complaint in December to add another count of perjury. Then when he chose not to take the plea offer, they're now moving to add an additional count of obstruction prejudicial to the defendant. Because this is now 4 weeks before the trial, which would interfere with his right to a speedy trial. And he shouldn't be put in a position to choose between an effective defense and to exercise his right to speedy trial just because the prosecutor failed to add a count about which they had information since the inception of this case. So for these reasons, we would ask that the motion be denied.
All right, the question before the court is a motion from the people to remand this matter back to the district court to allow for a preliminary examination to an additional charge of obstruction of justice with regard to the defendant. The question is, of course, a matter of discretion, not only to the court, but the extent of the discretion that is accorded to the people to actually make decisions regarding charging. And the court has to respect that discretion. As far as I'm concerned, the broad discretion that the law gives the elected prosecutor or the appointed prosecutor in this case does outweigh the concerns that the defendant has with regard to retaliation. The plaintiff does have the control, if you will, of the substance and matters contained in the information. And will be allowed to amend the information where remand is made in district court.
Judge Elsenheimer grants the prosecution's motion to remand the case to the district court for a preliminary examination on the proposed additional obstruction of justice count, and if probable cause is found, to amend the felony information filed in the circuit court. Under Michigan Court Rule 6.112H, the court may permit the prosecutor to amend an information unless the proposed amendment would unfairly surprise or prejudice the defendant. And in the 1993 case of People People v. Hunt, the Michigan Supreme Court held that an amendment should be disallowed only if it causes unacceptable prejudice to the defendant because of unfair surprise, inadequate notice, or insufficient opportunity to defend, each of which bears on the defendant's fundamental right to a fair opportunity to meet the charges against them. That standard sets a high bar that leaves courts with little basis to deny a prosecution's request to amend, absent a concrete showing that the defendant's ability to prepare a defense has been meaningfully compromised. And here, the reprimand itself addresses that concern. Under Michigan Court Rule 6.110, the preliminary examination, which is a hearing at which the prosecution must demonstrate probable cause to believe that a crime has been committed and that the defendant committed it, gives the defense formal notice of the new charge and a structured opportunity to test the evidence supporting it before the case proceeds. If probable cause is found, Trooper Sears-Patowski will be bound over on the new count, and the case will proceed to trial with 4 charges rather than 3. If no probable cause is found, the new count will be dismissed, and the case will return to the circuit court to proceed on the original 3 charges. Before we continue, I want to give a big thanks to the sponsor of this episode, Plod. Okay, real quick, this is not a credit card. This is the Plod Note Pro, and it's basically an AI secretary that helps make sure you don't miss something that might matter later. I'm constantly going through hours of footage, depositions, court hearings, and the moment you miss one statement, one contradiction, one key admission, your whole analysis falls apart. And honestly, it's not just in legal work. Situations like this happen all the time in real life. That's why I use this. I hit record, and Plod Note Pro gives me a full transcript with speaker labels, so I always know exactly who said what and when. But what I like most is that it doesn't just record and leave you with hours of audio. It actually organizes everything for you. You get a clean summary, key points pulled out, and you can search through it or even ask questions. Ask Plod pulls out the important moments and lets me instantly find what I'm looking for, so I can go straight to what matters. For example, if I'm reviewing a deposition and need to find where someone contradicts themselves, I don't have to scrub through everything. I just search it, and it's right there. And for anyone concerned about privacy, Plod Note Pro meets enterprise-level security standards. Your data stays yours. If you work with a lot of information, or any situation where what gets said might matter later, this is definitely worth checking out. They also offer a 30 days free return, so you really have nothing to lose. Use code COURT to get 10% off. Click the link in the description or scan the QR code on your screen and check it out. Thanks again to Plod for sponsoring today's episode.
All right, let's go ahead and take up the other motion that's been filed, this one by the defense, and this is a motion to disqualify this court based upon the potential of the court's colleague to be a witness in this matter. Let's go to you, Ms. Pop, if you'd like to make your argument.
So as the court is aware, there is an discharge here with 2 counts of perjury and will be on 2 counts of obstructions. The counts regarding the perjury, referred to testimony that he provided with on the first panel and during his wife's trial in Constitutional Compliance. And the obstructions related to statements that were made to Prosecutor Val Atwood. The defendant intends to call Judge Allen as a material witness in his case regarding contested facts in this case and regarding testimony that the defendants provided, as well as the testimony that Judge Allen would have to provide also pertinent to the defendant's motion to dismiss the perjury counts, as well as maybe testimony that the defendant will offer at the trial with an entrapment defense. And this includes testimony from Judge Hamlin regarding the defendant's testimony, but as well as conversations that Judge Hamlin has had with the prosecutors. So when a professional relationship exists between the presiding judge and a material witness, such as a judicial colleague, it can be reasonably inferred that there is a high probability of bias on the part of the judge. We did attach our State Bar of Michigan's ethics opinion that noted that if a witness, a judge is a necessary witness, then there could be an instance of bias on behalf of the presiding judge. And here, Judge Hamlin is a necessary material witness. This qualification is necessary when a judge is biased or prejudiced, but also when there's an objective and reasonable perception and that there's a serious risk of actual bias. Of course, the judge is not automatically required to recuse himself solely because a colleague is testifying, but he must recuse himself if his impartiality may be reasonably questioned or if there's an appearance of impropriety. So we believe that that could exist here. And if a colleague is a necessary witness regarding a contested fact like here, then the need for recusal is a lot more obvious. And the nature of the relationship could have an impact on this as well. If the presiding judge is close to the testifying judge in the same small chamber, the impartiality concern is even greater. And here we have a very small chamber with two judges who serve on 3 different counties that work very closely together. And if another judge is available, assigning a different judge seems to be the easy and best solution to avoid any issues. We have alternative options here. We have judges that could preside over this trial to protect the public's confidence in an unbiased judiciary and to protect the court and the parties from unnecessary appeals in this matter. Also, in light of the motion to dismiss that we have filed, which alleges prosecutorial misconduct that is so severe that we believe a dismissal is warranted. And because of the close relationship between the bench and the prosecutor's offices here, there's just a lot going on in this matter, and we believe recusal would be appropriate.
I believe the court can be unbiased and preside over this matter, and so therefore I'm asking you to deny the motion.
All right, thank you, counsel. Response?
And Michigan Rule 2.003C1B does provide a basis for recusal. In this case, it doesn't have to be a familial relationship. The judge, based on objective and reasonable perceptions, is either a serious risk of actual bias impacting the due process right of a party, or has failed to adhere to the appearance of impropriety. I believe this section offers a basis for what was recusing.
Defense counsel argues that Judge Elsenheimer should recuse himself, meaning voluntarily step aside and allow another judge to preside, because his close colleague, Judge Hamlin, is a necessary and material witness whose testimony will bear directly on contested facts in the case. Under Michigan Court Rule 2.003, recusal is warranted where a judge, based on objective and reasonable perceptions, has either a serious risk of actual bias impacting the due process rights of a party, or has failed to adhere to Canon 2 of the Michigan Code of Judicial Conduct, which requires judges to avoid impropriety and the appearance of impropriety in all activities, and to promote public confidence in the integrity and impartiality of the judiciary. State Bar of Michigan Ethics Opinion JI-57, issued August 24, 1992, addressed this scenario directly, concluding that while a presiding judge is not automatically disqualified when a judicial colleague testifies, the analysis turns on the closeness of the relationship and whether the colleague is a necessary witness on a contested fact, drawing an analogy to Rule 3.7 of the Michigan Rules of Professional Conduct, which bars a lawyer from serving as advocate in a trial where the lawyer is a necessary witness on a contested issue. Where both conditions are met, as the defense argues they are here, disqualification is appropriate to preserve public confidence in the integrity of the proceedings.
All right, I think the filing is timely. Number one, I also think that there's a basis for the request in the old rules. So I appreciate the procedural arguments being raised by the defense, by the people. But I do think that this is an appropriate motion to be filed, and it was properly filed. The argument is that because of the close relationship between this court, me, and as chief judge in this circuit, and my colleague, Mr. Hamlin, Judge Hamlin, who is the presiding judge in the underlying matter involving the defendant's wife, which led to the genesis of the charges that have been brought against this defendant, that there is at least the appearance of impropriety potentially, such that public confidence would be supported should this court grant the motion from the defense and step aside and allow the Supreme Court to appoint another judge to hear the matter. The court does maintain a very close relationship with Judge Hamlin, as one would expect. We work very hard. We communicate together regarding cases. The court does provide guidance at times to Judge Hamlin in the same way that Judge Power provided guidance to this court when I started 10 years ago. And frankly, Judge Hamlin provides guidance to me on criminal matters because he's such an expert on occasion. So we do have a very close working relationship that I think is certainly well known to the bar in this community, and frankly, I think expected by this community as well. With that said, the court feels confident that it can act with impartiality in this matter. But I do also think that the fact that we're talking about a sitting judge who is my charge, if you will, as chief judge, whose credibility could be called into question, certainly as part of the motion practice that's been filed and adjourned, that there is a sufficient issue to justify this court stepping aside and allowing the Supreme Court to identify another judge to handle this matter. I'm very concerned, given the fact that we're talking about a member of the state police who's been charged with these serious crimes. We're talking about witnesses that include members of the prosecutor's office here in Grand Traverse County. We're talking about witnesses that include a sitting member of this bench that the public should have full faith in the process going on and shouldn't even have an inkling, a sniff that there is something afoot beneath the system or behind the curtain that is resolving this matter in advance of a fact finder ultimately making a decision at trial or whenever this matter is ultimately decided. To preserve that confidence in the system, I do think that the wisest course here is for this court to do exactly that. I'm going to grant the motion. The court will go ahead and notify the Supreme Court Administrator's Office to find another judge to sit in this matter. That judge will be appointed most likely next week.
Judge Elsenheimer granted the defense's motion for disqualification and referred the matter to the State Court Administrative Office for the appointment of a new judge. The prosecution's motion to remand for a preliminary examination on the additional obstruction of justice count was also granted, and the case returned to the district court. Following a preliminary examination on April 16, 2026, the defendant was bound over on the additional obstruction charge, and he pleaded not guilty. As of the date of writing this episode, the case has been reassigned to Judge Colin Hunter and remains pending. This hearing serves as a reminder that the legitimacy of the judicial system rests not only on judges making correct decisions, but on the public's confidence that those decisions are made without favor or bias. A judge occupies a unique position of public trust, and with that comes an obligation to accept a level of scrutiny that most people will never face in their professional lives. When the circumstances surrounding a case, even in the absence of any actual bias, could reasonably cause an informed member of the public to question whether the process is fair, the best decision is for the judge to step aside and allow another judge to decide the case in order to preserve the public's opinion of the court's integrity. Judge Elsenheimer's willingness to recuse himself despite his personal confidence in his own impartiality reflects precisely the standard Canon 2 of the Michigan Code of Judicial Conduct demands, that a judge avoid not just impropriety, but also the appearance of it. Public confidence in the courts is fragile, and once lost, it is difficult to restore. When the stakes are high, like in this case where a law enforcement officer stands accused of betraying the very oath he took to uphold the law, then the community deserves a verdict rendered by a process that no one can reasonably question. Let us know if there's a case or courtroom interaction that you would like us to explore in the comments below. Thank you for watching, and don't forget to like and subscribe so we can help foster a more informed society.